Hello again. Today we're going to talk about Section 230 of the Communications Decency Act of 1996. Now that's a big mouthful, but really that Section 230, are the 26 words that made the internet what it is today, for better and for worse. Of course, it's still being debated. It began with the question of whether the internet was a publisher or a platform. The difference is if you're a publisher, like Time Magazine, where I used to work, or the New York Times, or even a website being a publisher. If you're the Daily Beast, you're a publisher. That means you're responsible for the words. You're the one who curates the words on that page. If you're a platform, it means you're just neutral. It's like being a bulletin board in some public post where people can just put up whatever they want. And you're not necessarily responsible, even if you put up that bulletin board, you're not responsible for everything people post on it. One example of that came in a case in 1959 called Smith versus California. And somebody was upset about a book and sued about a book, but also sued the bookstore. And the Supreme Court of the United States rules that a distributor, such as a bookstore, you can't hold them liable for everything that's in every book that happens to be on their shelves. That would have, the court said, quote, an effect of inhibiting the freedom of expression. And so the notion of just being a distributor or a platform and to be able to sue them, that's just as silly as saying you can sue the telephone company because somebody gets onto a conference call and says something libelous on that conference call. So that was the great dichotomy. And the question was whether online services in the old days were actually publishers or whether they were what we will call platforms, meaning they just distributed things. And this is even before the World Wide Web was a popular thing. And it begins with Compuserve, one of the online services that predates the public being able to go on the web directly. Compuserve was an online service. You dialed up and you got to a whole lot of places on it. And they had newsletters and people posted things. And one of the newsletters that one of the customers posted said something that seemed to be libelous. It attacked some other online newsletter, and it got sued, but the people who sued also sued Compuserve. The court found that Compuserve couldn't be held liable. It didn't moderate its content. It never checked. If somebody uploaded something onto a bulletin board, Compuserve didn't try to moderate it, didn't try to curate it, and thus the court said it couldn't really be held responsible for everything people just posted or put on, just like whatever you put on 4chan or 8chan, or for that matter, whatever you may post on Facebook, which is how this story will eventually end, as a discussion of Facebook. But there was a contrary case in 1995, a few years later, against Prodigy, which was a very similar online service. And an anonymous user posted something on Prodigy accusing an investment firm named Stratton Oakmont of committing fraud. Stratton Oakmont sued for libel. Prodigy, unlike Compuserve, tried to moderate some of the content. It wasn't quite like Facebook. It didn't let you put up just whatever you wanted. It had moderators and editors of customer content to make sure the stuff that people posted wasn't horrible. And so it loses the case. By being responsible and trying to moderate and edit the content, it loses the case because the court rules in this 1995 major decision that it was a publisher, not just a passive carrier or not just a platform. And so it was legally responsible for what was up there. I, at the time in 1995, was working at Time Magazine's online services. We had created something called Pathfinder. We were also on America Online, one of the other online services. And we had bulletin boards, and the bulletin boards had all sorts of content. If we ran a piece about burning the flag, or we ran a piece about legalizing marijuana, there'd be bulletin boards, and all sorts of our readers would post things, and they'd post their opinions. It was like letters to the editor, and it was to some extent curated, like editors to the letters to the editor were. We had a wonderful guy named Dick Duncan who stayed up at night and kind of read as much as he could through all the comments. And if he saw something really bad or something libelous, he took it down. After the Stratton-Oakmont decision, the lawyers at our company said, quit moderating your content. Quit checking it. Quit trying to curate it or make sure that people aren't putting hateful or libelous things up. Because to the extent you do any moderation at all, that makes you legally liable, according to this case against Prodigy. But if you don't do anything, you just wash your hands and you never look at what all the people post on your pages, then you're like Compuserve. You're not going to be held liable. Well, two congressmen, two congressmen, a Democrat and a Republican. On your right, there's Chris Cox, a California Republican. He looks at these cases and said, that's exactly the wrong result. That's exactly the opposite of what we want to have happen. How are we going to have an internet that will blossom if companies get punished for trying to keep things clean? And he said, this struck me as a way to make the internet a cesspool. By the way, he was right. I don't know if you've checked recently, but a lot of the internet is a cesspool. And part of it has to do with the fact that if you don't moderate, if you're Twitter, if you're Facebook, if you're 8chan, 4chan, if you're something like that, your Instagram, and you don't moderate in any way customer content that's being posted, you're not liable. You can't be sued. So he teamed up with his close friend in Congress, a Democrat named Ron Wyden. That was way back when Republicans and Democrats could be friends and do things for the common good. And they produced a section called Section 230 that was designed to overrule the Stratton-Oakmont decision and say that service providers could moderate content without making themselves liable for everything anybody posted. If you acted in good faith and you were just trying to take down the horrible stuff, if something slipped through, you weren't going to be held liable for that. And what it was just a small section, that's why it's called Section 230, buried in something called the Communications Decency Act, which was a big act that had sort of a different purpose, which was to keep porn off the internet. And here are the 26 words in Section 230 that became, as I said, the 26 words that made the internet what it is today. And those 26 words are: no provider or user of an interactive computer service shall be treated as the publisher or speaker of information provided by another information content provider. So that gave you immunity if you're just posting other people's content. And the reason it gave immunity was so that these service providers, these platforms, would feel comfortable moderating and taking down indecent things or hateful things or libelous things, but they wouldn't, by doing so, expose themselves to a legal liability. It passed by a near unanimous vote. Clinton signed it into law in 1996. The main part of the Communications Decency Act, the whole part about you can't post porn and other things, was actually declared unconstitutional as a violation of free speech. But Section 230 remained intact. So the only part of the bill that stays intact are these 26 words that basically make the distinction that says internet platforms such as Twitter, Facebook, Instagram, or any website or online service that allows people to post content, they can make good faith efforts to keep hate speech off, but in return, they get immunity from being considered a publisher. Publishers can be held guilty of libel for things that they publish, but an online service isn't a publisher. It's just a platform. We'll see how that turns out in our next lecture.